Dr. Bill Chris, legal and political historian. Thank you so much, and welcome back to Ion Politics.
Thank you very much.
So, you looked over the majority ruling from this three-judge panel that came out this week that blocked the use of the new 2025 congressional maps that were approved by Texas Republicans. And what did you make of that majority ruling?
Well, it's a very long opinion. What it basically says is that the Republicans in the legislature and in the executive branch, with the exception of the Attorney General, Paxton and his office, who observed early on that this might be a problem, committed what we would call in soccer an own goal. They sort of headed the ball into their own net and scored a point for the other team or a goal for the other team because they took the U.S. Department of Justice, Trump's Department of Justice, at their word with respect to whether or not the law would require that Texas redraw its congressional districts to comport with the Voting Rights Act.
And essentially, because that Justice Department letter last July said that these four coalition congressional districts were unconstitutional. And after that, the governor then called for a special session to redistrict. And so I'm wondering, do you think that letter was the problem here that the legislature and Republicans just couldn't get around?
I think that was the main problem for Judge Jeff Brown, who wrote the majority opinion. That's certainly foregrounded in his opinion, but not just the letter from the Justice Department, but the concurrence that that letter received, the way in which it was used by the governor's office to essentially justify the call for a second special session for the purpose of redistricting. The letter says that you're required to address these four congressional districts because they're violative of the Constitution and the Voting Rights Act.
And let me ask you, because the Republicans have said from the get-go that race was not a factor, partisanship was a factor, which is allowed while racial gerrymandering is not allowed. And I'm wondering because if it was just partisan, why did the Justice Department then need to send this letter if President Trump wanted five new congressional seats, and he certainly told that to Republicans that he wanted them? Why not just go with that as opposed to this Justice Department letter?
This is a fascinating question, Jack, and the only answer that we can speculate about that, the only answer that I can come up with is that the people who decided to follow the instructions of that letter had two motivations. One would be to do precisely what President Trump asked them to do through his Justice Department. It's like, okay, this is what the president's asking for. This is what we're going to give him. And the second reason is I think there may have been some hesitancy among some of Texas's elected officials to just brazenly say, yeah, this is all about just trying to get an advantage for the Republicans in Congress. I think there was some reticence in certain circles about just coming out and saying that, which would have made what they did substantially more bulletproof than it was.
At least from the legal perspective.
Yes, I think what you have here is a tension between political considerations and legal considerations. So politically, I think there were several Republicans who must have made the calculation that this won't look good if it appears that all we're doing is just obeying the president to give him four or five additional congressional seats in Texas. That just looks too much like a power grab. We have this cover from the Department of Justice in the form of a letter that says, hey, this is legally required. You're not allowed to have these coalition majority districts. The law has changed, and now we've got to undo these coalition districts. And so that was kind of used as a justification for what the legislature did. And from the Republican perspective, it's unfortunate that they did that because that's what ended up hanging them with respect to the entire process.
So the state, as you know, almost immediately filed an appeal with the U.S. Supreme Court, And just in the last 24 hours, they have filed a request for a stay. How likely do you think that the U.S. Supreme Court will uh, decide to involve itself in this? And then, of course, the big question is when. And then, what about this stay from the court that made this decision?
Well, based on past history, based on precedent, I think it's pretty likely that the Supreme Court's going to get involved, and I think it's fairly likely that they'll issue a stay for, and these are the reasons. The first reason is that unlike most federal lawsuits, when you're involved in a voting rights case, as this one is, there are special rules that apply, and one of them is that that any appeal goes directly to the United States Supreme Court without the intervention of the intermediate Fifth Circuit Court of Appeals, that would be the intermediate court for our state. That's just by statute, and so the Supreme Court's not going to be able to duck this issue. They're going to have to decide the appeal. And given that they're going to have to decide the appeal, it's sort of routine for the Supreme Court to grant this kind of emergency relief, to leave things as they are until they get a chance to evaluate the merits of the case. So I would say the odds are fairly likely that the Supreme Court will both issue a stay pending the appeal and also end up taking up the appeal unless it becomes moot, because the problem we have here is a time problem. If the Supreme Court goes ahead and issues a stay, unless they decide the appeal extremely quickly, it may not make any difference. The election may have already happened.
Well, that's what I was going to ask you about because doesn't the lower court, the three judge panel here, can't they issue a stay on this pending what happens with the Supreme Court? Isn't that what the state is asking for? And if they do that, what impact will that have on their ruling that they just issued?
The three judge panel's already basically issued an injunction. I mean, they've already issued a mandatory injunction that the state should proceed with the election based on the old 2021 maps. So that's already in effect. The three judge panel's not likely to stay their own ruling about that injunction based on what Judge Brown says in the majority opinion. So that's not likely to happen. What's going to happen is that Justice Alito, who's one of the most conservative, if not the most conservative members of the Supreme Court, is the member of the court that's assigned to our circuit. He will get the first look at the request for an emergency stay, and he can issue that stay himself. He's more likely to, get a majority of his colleagues to agree with him about that and to participate in issuing the stay. This is the so-called kind of shadow docket where you don't get an opinion, you just get an order out of the Supreme Court, or you get no order out of the Supreme Court, and then the Supreme Court will take up the merits of the case and they will review the findings made by the three-judge panel.
And so any number of things could happen, right? They could just say, we will stick with the lower court's decision, this three judge panel, or they could reverse it. They could delay the filing period, right, for just the congressional offices if
Yeah, yes.
necessary.
Yes, that's been done before. That's been done before in Texas and elsewhere, where these court opinions and this litigation ends up interfering with the normal schedule of events when it comes to elections, because it's November. We're already coming up on the filing deadline for candidates to run for office, to run for these congressional offices. And so, yeah, I mean, it's quite a state of disarray right now. And no matter which way it goes, people are going to be uncertain about the future with respect to these congressional districts. It's really unfortunate, Jack, in my view, that the Supreme Court a few years ago decided that you can just partisan gerrymander all you want without any kind of judicial scrutiny. That's why we have this problem. is that judges are sitting there trying to ferret out how much role of a role did race play, how much of a role did partisanship play. Does it really matter? I mean, to the ordinary citizen, if you look at the way these districts are drawn, whether they're drawn based on race or based on partisanship, they look ridiculous. That's why they're called gerrymanders, is because they're in the shape of a weird looking dragon or salamander. And we got to do something to make this whole process of redistricting more rational. We might be better off having machines do it and just input into the machine parameters that will allow us to have these, very regular, compact, ordinary looking districts.
And Ben, let me ask you to your point, because, you know, there's always this struggle as far as what the courts should really be doing and, separation of powers, et cetera. And, is this something that the courts should be deciding? Is this something that, the legislatures, the state legislatures should be deciding, et cetera? There is that, constant, not struggle, but I guess for the lack of a better word, struggle.
Yeah, no, there's an inherent tension between what the Supreme Court has historically for many years called inherently political questions. And one of the most inherently political questions that the court generally refrains from involving itself in is this business of redistricting. It's sort of seen as the ultimate political sausage making, where this is just kind of the, democracy's messy. This is just kind of the way we do. Let the parties fight it out in the legislature and at the ballot box, and we judges, we're ill-equipped to deal with this. And that's a valid, value for judges to hold. But there's also the value of one person, one vote. And both the Constitution, the 14th Amendment and the 15th Amendment, and the Voting Rights Act are very clear that you can't dilute a person's voting strength or pack people into districts on the basis of race, because that dilutes the ability of their vote to count. So those two things are always in tension. My own view is that race should not be the only reason why courts need to look at these districts. We live in an era where we have computer-assisted drawing, we have artificial intelligence, we have all kinds of neutral ways to draw these districts without legislators getting in there and basically just trying to feather their own political party's nest.
And let me ask you about what's called the Purcell principle, which the court came out back in 2006. And it said that the court should not be changing election rules during the period prior to an election. And here we are. We don't have an election per se, but this is the filing period that you mentioned before, started November 8th, where candidates can file their campaign paperwork. And they've got 30 days essentially to do it because the deadline is December 8th. And here this decision comes out on November 18th. And so you called it disarray. I know the state of Texas, in its motion for a stay, called it chaos. So what about that?
Well, the Purcell doctrine is mentioned both by the majority opinion and the dissent in this case because it's an important doctrine. Like most legal doctrines, it's not an absolute doctrine. So, is it too late if it's 4 months before the election? Is it too late if it's a year before the election? And so on, right? And the problem is that in this case, for example, what the majority opinion says, what Judge Brown's opinion says is it actually would have been impossible for anybody to challenge these districts any sooner than they did because the districts weren't even drawn until a second special session, which itself didn't conclude until late summer. And the plaintiffs in the case who were challenging those districts filed suit almost immediately. So the Purcell doctrine's not an absolute. It doesn't have like a specific number of days or weeks that the court can intervene. And the reason for that is because if you have a specific cutoff that judges enforce, you're going to have situations like this where you can't even challenge the map because the legislature will just wait until it's too late and you're within the Purcell buffer zone so that nobody can challenge it, which is essentially what happened in this case. Now, what Judge Smith says in his dissent is that the reason why this couldn't have been done any sooner shouldn't be blamed on the legislature or the governor waiting until a second special session to do it. It should be blamed on the Democrats who broke the quorum by leaving the state so that any vote on these maps would be postponed. Interesting dispute.
I was going to ask you about this dissent from this judge because it's obviously made national headlines. It's quite the read. And I know that dissenting opinions aren't the governing opinion here, the majority is, but it certainly has raised a lot of eyebrows in the tone, in the um, personal criticism from one judge to the next. And so I'm wondering what were your takeaways from this?
Well, when I read, and I had to read it quickly because it's quite long. It's about as long as the majority opinion. The first impression that you get reading the dissent is that Judge Smith, the dissenter, is extremely angry. Um, and he's angry for personal reasons that have to do with attending a colleague's funeral, not being able to be not being able to be included in reviewing the majority opinion and have not having sufficient time to write his dissent. He writes in his dissent that he communicated that to the majority. But there's more than that. I mean, he makes an accusation of, uh,
Judicial activism.
well, not just judicial activism. He says something along the lines of, he'd never seen anything this bad from a judge. That Judge Brown, somehow did something, wrong or not good. And this is unusual. I've only seen something like this one other time in the last 30 or 40 years, and that was a battle between Texas Supreme Court justices over waiving deadlines for challenging parental authorization for a minor to have an abortion. And that's a dispute that goes back probably at least 20 years, where there were dueling opinions and the justices were arguing about not the merits of the case, but the procedures that were used to write the opinion. And it goes further than that. I mean, Judge Smith talks about how the primary beneficiaries of this decision are going to be George and Alex Soros, who are kind of the boogeymen of the extreme right wing in this country. Um, it's unfortunate that he was that upset, and certainly, as you say, it gained national news, and so this is not a case that's going to go under the radar. This is a case that the Supreme Court already knows about, and I suspect that's one reason for the vituperation in Judge Smith's opinion is to draw attention to what he considers to be something really bad.
But do you think he had a point in the sense of the fact that normally judges do wait for the dissent to come back so that they can look at it, et cetera? I realize the timing aspects of this case and the deadlines, et cetera. But did he have a point there or no?
Well, this is an unusual case, so I can certainly understand his being upset because that is the normal procedure. On the other hand, if you look at the details of his opinion, it's not like Judge Brown didn't reach out. He did provide him with an outline of what he thought would be his opinion several days before issuing it. He did tell him in advance, we expect to issue the opinion on, I think, November the 18th. And Judge Smith just wasn't available. He had legitimate personal reasons for not being able to address those communications very quickly. And so it's just an unfortunate situation. I certainly can understand why he would be frustrated about that because it is normal procedure to include all those things. And Judge Brown says, or said, as indicated in the opinions in the case, Hey, I understand that. Normally, I would want to have your dissent before I finish my opinion. And usually the majority wants to do that so they can address whatever objections are raised in the dissent. Judge Brown's position was, we obviously are behind the eight ball on this already in terms of time. I'm sorry, but this is when we're going to issue the opinion. So I can understand why both of them took the positions that they did.
And my last question to you, and I appreciate your insight. Do you think anything comes of this, dispute, this bitter dispute from one judge to the next?
Well, I certainly hope not. The one or two times I've seen something like this before, there aren't formal complaints that are lodged against one judge or another. The thing that I think is most lamentable about this is that such a strenuous kind of use of language, particularly by judges, has it can have a tendency to undermine public confidence in the judiciary, and this we don't want. It's okay to disagree. It's okay to disagree with fervor, right? But when that gets to the point of uh, personal uh, personal types of statements about each other. That's something that we as lawyers don't do. And the real problem too is if you're the judge who's on the receiving end of that, whether you're being criticized by the press or by a litigant or someone else, you really can't respond. You're not supposed to respond, and there's no provision for writing. I mean, I guess you could write a supplemental opinion or something, but I don't think Judge Brown's going to do that. And he was contacted for comment, and as I expected, he didn't say anything. And I don't think Judge Smith will say anything more than what is in his opinion, because he's certainly entitled to put in his opinion whatever he feels would be appropriate under the circumstances of the case.
Dr. Bill Chris, thank you so much. We appreciate it.
Thank you, Jack. Good to see you.